Earlier today, something occurred inside a federal courtroom that rarely happens and almost never unfolds in public view. It was not the verdict itself. It was not the judge's words. It was the moment the human body reacted before the legal process had finished speaking. Most verdict readings are procedural. They move at a predictable pace. Count numbers are called. Jurors respond. Lawyers listen. Defendants brace. It is a ritual everyone in that room has seen before. Yesterday, that ritual broke. The jury returned after more than 11 hours of deliberation spread across 2 days. The courtroom reset into its familiar posture. The judge took the bench. The jurors were seated. The clerk stood to begin polling the verdicts. The indictment contained 43 counts. Each count required a separate finding. That matters because federal juries do not deliver global judgments. They evaluate each charge independently. Mixed verdicts are common. Guilty on some, not guilty on others. It is one of the system's safeguards. That safeguard did not appear yesterday. The clerk began with the first count, bank fraud. The foreperson stood and answered clearly, "Guilty." The defendant did not move. The second count was called, "Guilty." Still no movement. By the fifth count, something subtle changed. Not outward reaction, internal strain. His jaw tightened. His breathing shifted. The body was beginning to register what the mind was resisting. By the 10th count, the pattern was unmistakable. Guilty. 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 This is where many defendants begin to recalibrate. Hope narrows. Calculations begin. But yesterday the sequence did not slow. Count after count returned the same answer. By the midpoint of the verdict reading, the courtroom was no longer processing information. It was observing consequence. The defendant's hands gripped the edge of the table. His posture stiffened. Small movements appeared, barely noticeable to casual observers, unmistakable to anyone who has spent time in courtrooms. The kind of movements that signal internal distress rather than performance. At roughly the 30th count, his eyes closed briefly. Not in protest, in overload. Then, before the clerk finished reading the verdicts, his body failed him. This was not a theatrical collapse. There was no dramatic gesture, no sound, no appeal. His body simply stopped maintaining itself. He slumped sideways and slid from his chair onto the floor while guilty verdicts were still being read aloud. The judge halted proceedings immediately. Marshals moved in. One checked responsiveness. Another called for medical assistance. The defense attorneys dropped to the floor beside their client. The jury reacted instinctively, some standing, some covering their mouths, before being ordered out of the room. This detail matters. The judge removed the jury instantly. Judges are acutely aware of juror psychology. She did not want jurors internalizing responsibility for a medical emergency. The verdict was theirs, but the collapse was not something they were meant to carry. Within minutes, paramedics entered the courtroom. Vitals were taken. Blood pressure elevated. Heart rate extreme. Acute stress response. This was not performance. This was physiology. After a brief recess, the defendant returned to the courtroom. Pale, disoriented, but conscious. The judge confirmed, on the record, that he was medically able to continue. The clerk resumed. The remaining counts were read. Guilty, guilty, guilty. Every count. 43 charges, 43 convictions. No acquittals. No splits. No ambiguity. That outcome requires explanation because it is not routine. Federal juries are cautious. They are instructed repeatedly that each count stands alone. When a jury convicts on every count, it signals something specific. Not enthusiasm. Certainty. It means the jury rejected every defense theory. It means they found the evidence consistent across charges. It means credibility determinations were decisive. In this case, the evidence spanned documents, testimony, and recorded communications. Financial records showed false representations submitted to obtain loans. Bank witnesses testified about reliance on those representations. Emails demonstrated the defendant's knowledge of inflated valuations. Cooperating witnesses described internal coordination. Audio recordings captured discussions about concealment. Each count rested on overlapping proof, but each required independent findings. The jury made those findings 43 times. This is why the verdict matters beyond symbolism. Sentencing in federal court is not emotional, it is mathematical. Convictions aggregate. Patterns matter. Scope matters. A defendant convicted on some counts can argue limitation. A defendant convicted on all counts cannot. A complete conviction tells the court that the conduct was sustained, intentional, and comprehensive. Judges consider that when assessing offense level, enhancements, and deterrence. This is the point where the case moves from trial to consequence. But before sentencing is even calculated, one more legal reality enters. The defendant testified. He denied wrongdoing. He claimed reliance on advisors. He rejected intent. The jury rejected him entirely. In federal sentencing, acceptance of responsibility is a factor. Testifying falsely eliminates it. Judges are permitted to consider obstruction when a defendant lies under oath. That combination, total conviction plus rejected testimony, narrows discretion. This is why the collapse matters. Not as spectacle, as signal. The human body processed what the legal mind had not yet finished accepting. Decades of exposure collapsed into minutes of realization. Once a jury returns a verdict like this, the courtroom energy changes immediately. The trial is over, but the case is not. What follows is not argument or persuasion, it is calculation. Federal sentencing does not begin with emotion, it begins with arithmetic. Within days of the verdict, the court orders the preparation of a pre-sentence investigation report. This document becomes the backbone of sentencing. It does not relitigate guilt. That question has been answered 43 times. It measures scope, harm, and responsibility. The probation office examines the entire record. Not just the counts of conviction, but the conduct underlying them. Financial loss totals, number of victims, duration of the scheme, degree of planning, role in the offense, obstruction, false testimony. Each factor carries weight. In cases involving fraud, quantity matters, but pattern matters more. A single false statement may suggest recklessness. Dozens of coordinated acts over multiple years suggest design. Judges are instructed to consider whether criminal conduct was isolated or systemic. A verdict convicting on every count answers that question. Systemic. This is where the guidelines accelerate. Loss amounts drive the base offense level upward. Each enhancement compounds the range. Sophisticated means, multiple victims, leadership role, obstruction of justice. Each applies independently. When stacked together, they produce sentencing ranges that surprise people unfamiliar with federal court. This is why white-collar sentences often exceed public expectations. There is no jury at sentencing. There is no doubt left to resolve. The judge works from a framework designed to reflect harm and deterrence. And judges pay close attention to how the jury spoke. A jury that convicts on some counts leaves room for interpretation. A jury that convicts on all counts sends a different message. It tells the court the evidence was not close, that credibility was decisive, that explanations were rejected. That message affects discretion. The defense will argue mitigation. They always do. Lack of prior criminal history, family circumstances, community contributions, health, age. These factors are permitted, they are considered, but they do not erase conduct. The prosecution will argue aggravation, scope, duration, impact, deception, lack of remorse, false testimony, each supported by the trial record. And then there is acceptance of responsibility. This factor is misunderstood. It is not about regret after conviction. It is about acknowledgement before trial. Defendants who plead guilty and accept responsibility receive reductions. Defendants who go to trial, deny wrongdoing, and testify falsely do not. In some cases, judges apply an enhancement for obstruction based on perjury. That does not punish testimony. It punishes deception under oath. The jury's rejection of the defendant's testimony opens that door. This is where sentencing exposure expands dramatically. The defendant's collapse during the verdict does not affect this analysis. Judges do not sentence based on visible distress. They sentence based on the record. And the record here is unambiguous. 43 convictions mean 43 findings of guilt beyond a reasonable doubt. It means the jury believed the defendant knew what he was doing and did it anyway. Sentencing hearings often occur months later, but the shape of the outcome is visible almost immediately after a verdict like this. Restitution will be ordered. Assets will be forfeited. Financial penalties will follow incarceration. Federal fraud sentences are designed not just to punish, but to unwind benefit and compensate victims. And incarceration is not symbolic. Federal sentences are served at roughly 85%. There is no parole. Time imposed is time served. When guideline ranges reach decades, age becomes relevant not as mitigation, but as consequence. Judges are aware of this. They do not ignore it, but they do not allow it to override deterrence. This is where public debate often diverges from legal reality. Some view nonviolent crime as less deserving of severe punishment. The law views sustained financial fraud differently. It treats it as an attack on institutional trust. Banks rely on representations. Markets rely on integrity. When those systems are manipulated deliberately, harm spreads beyond immediate victims. That is why sentences escalate. Deterrence is not abstract. White-collar crime is calculated. If consequences are tolerable, behavior repeats. If consequences are severe, behavior changes. Congress built that logic into the guidelines. The judge will hear arguments from both sides. The defendant may speak, victims may speak. The court will consider letters and reports. Then a sentence will be imposed. At that moment, the case becomes final in its most important sense. Appeals may follow, but appeals do not retry facts. They examine procedure. A verdict supported by overwhelming evidence and unanimous conviction is difficult to disturb. Appellate courts defer to juries on credibility and fact-finding. This is why the collapse during the verdict mattered, not as drama, but as marker. It was the moment when the defendant's internal understanding caught up with the legal reality. The system had already reached its conclusion. The body reacted before the mind finished processing it. Trials are slow. Consequences arrive suddenly. What happened in that courtroom was not extraordinary because of the physical response. It was extraordinary because of the clarity of the verdict. 43 charges. 43 guilty findings. No ambiguity left for interpretation. The sentencing phase will now proceed as designed. Methodical, structured, unemotional. And when sentence is imposed, it will reflect not just what the defendant did, but how completely the jury rejected every attempt to explain it away. That is how the federal system works. And that is where this case now stands.